Hello, everyone. Over the next 5 minutes or so, what I intend to do is really talk very briefly about some changes which are proposed under the new rules which are applicable to social media intermediaries and what possible tax implications may be unintended, which could actually be arising out of those rules which have just been put out. Now, these are rules which have been notified under the Information Technology Act. This is not a new enactment. This is not a law that's been brought into force. It's really a rules that's been notified under the Information Technology Act, where the central government had powers under a delegated legislation to frame rules for certain aspects. And now what they have framed rules for is two things. One is for a self-regulation or regulation of the content on social media intermediaries and online journals and newspapers, and also providing an option for grievance redressal for its users. Now, these rules apply to social media intermediaries, and social media intermediary has been defined quite widely to include any intermediary which enables online interaction between two or more users and allows them to create, upload, share, disseminate, modify, or access information using the services which are provided by the intermediary. Therefore, it would cover not just the OTT platforms, social media apps, plus all the messaging apps which are there. Now, there are multiple things which are prescribed in these rules, including requirement to file statements periodically, give data, have control over users, verification of users, even something as onerous as being able to identify the originator of the message, the first person who really sent the message where it's been forwarded multiple times. Now, leaving aside all of those kind of things, there are a few changes which could impact tax positions of some of these companies, and those relate to two things broadly. One is the law, the rules require three officers to be appointed by social media intermediaries. One is a chief compliance officer, second is a resident a grievance officer, and third is a nodal officer who will be available 24 bar 7 to regulators, security agencies, etc., for grant of information, complying with their requests in relation to users, messages, etc., which are put out. Now, the rules require all these three officers to be residents in India. And, nodal officer who's there 24 bar 7 for complying with requests may not necessarily be one. He or she may have a team of people, but we leave that aside and say there'll at least be three officers. And the rules also say that one officer can't play the multiple roles. So we'll at least have three officers who are resident in India. The rules also require the significant social media intermediary, which is a social media intermediary which has more than a prescribed number of users, to also have a physical office address in India, which is displayed on their website or on the app, and is available for users to for grievance redressal and things like that. Therefore, today you suddenly have a significant social media intermediary who's never had a presence in India, who's always had its data outside, servers outside, but users in India who are accessing, suddenly having a requirement to have three employees at the minimum and an office address in India. Now, would this become a place at its disposal, a place of business in India, and what will be the implications? A mere presence or having a place in India does not necessarily lead to taxation, either under the act or under the treaty. There are exceptions for preparatory auxiliary work. Could a company argue that this is only for the requirement of a compliance under a regulation or a rule and does not necessarily mean that there will be a taxable presence? But we need to remember that permanent establishment, business connection, etc., are quite tricky, and there are no simple answers for this. We've seen that even something like access to a Formula One track over 3-4 days actually had to finally get settled at the Supreme Court, and these are not issues which will have easy answers. Companies need to pay attention to what the roles and responsibilities of these employees would be, how would these get documented, how would the office presence be created? Would there be a branch office, a liaison office, a subsidiary which complies with this? And what tax impact it would have on the position of the foreign company which thus far had not had a presence here? That's one aspect from a pure income tax perspective. And again, a presence being created does not necessarily mean that there will be a tax liability. There would be the exercise of attribution to be undertaken. There may not be much to attribute or nothing to attribute here if the presence and the employees who are present are only compliance officers and nodal officers. But again, like I said, that by itself requires detailed examination, evaluation of all the principles that have been laid out thus far and what it means. Second could be that what it does to their position under the GST law. Is there a requirement to obtain registration, etc.? Needs a closer look. And lastly, some of these companies could have been liable to equalization levy, and some of them may not have been, given that they may not have had revenues in India. But it's important to remember that equalization levy does not apply where there's a permanent establishment, and therefore it could also have end up having an implication under the equalization levy as well. So, some of these aspects need to be taken care of. This is a space that we will be watching closely, and we will come back with some more detailed analysis and comments. And this is a space that needs to be keenly watched out for. Thank you.